There are people here. Yeah, we're screwed here, so. Can you hear me? Let me know if you can hear me right now. Type something in. Hello, 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 anybody? Can you hear me, is what I asked. Can you hear me? Can you hear me? God, man, nobody answered the damn question. Anyways, yeah, I'm screwed right now, so. We had a tree come down in my neighbor's branch, or a neighbor's branch, because she's like, oh, the trees are living. I don't want to cut branches down. You know, the same one idiot with the chickens and everything. So her branches always destroy their cars. So they always park across the street knowing that their branches are dangerous. So then they, one of them, now right now there's like this rain and it's only 32 degrees still. So now there's ice and one of their branches came down and landed on the power line that goes across the street. And then it ripped the power line out of their house and it's all the way across the road. And mine somehow miraculously stayed up there. And then a little bit later, a tree across the street with ice was hanging over the power line, and then smoke started billowing out. And then the transformer blew on our 9-house cul-de-sac. So we're probably like toast. So I'm actually streaming right now using my cell phone, some backup battery powers, and etc. Yeah, it just sucks. Jeez. So I don't know when this is coming back on. So again, you guys, like I always say, I could use your support on this stream because who the hell knows? Right. Can you hear that sound right there? That's on the roof. Ice chunks falling off the tree. Yeah, so I'm just kind of sitting here. I might do this for like an hour or so and then try to come back on later. Yeah, it's a freaking nightmare. Let's see. God. It's brutal. Yeah, we just had one on our street after I had survived, and I was like, oh, God, and then, boom. I mean, you can hear all the sounds outside. It's crazy. Over and over and over again. Yeah, so we did, you know, we just did the last stream that had, was a live stream of the court hearing. You can kind of see the writing on the wall. The Supreme Court was definitely, hey, thanks, Kubi. And yes, everybody, please help support the channel. I know I say it over and over and over again, but it's absolutely necessary for me to keep doing these shows, even during a freaking storm. All right, so the, yeah, I played the live stream earlier. I boosted up the audio. I think I probably had the best audio playing on any of the channels out there because I knew what I was doing. I actually boosted it so you could hear the damn thing, and it was really clear. And but you could tell the Supreme Court of Indiana had deference to the convicted killer's rights, him wanting to have an attorney. Hey, look at that. It's Tally Gal 3. What's going on? I tried to get a hold of you. I was like, man, where the hell have you been? Thanks for your commitment to, hey, thanks so much, Jen Lowe and Cali Gal 3. Moved to the desert. Right, exactly. But I just got this freaking studio built. Yeah, it took forever to save up for that one. Anyways, thank you guys so much. I appreciate it. Yeah, so it seems like they had deference to, obviously we have the Sixth Amendment, right? So he had the right to choose his counsel, and then, you know, I guess the thing that I was always concerned about was that he, even knowing what they had done, said, I want those attorneys. And it seems like, I mean, I have been in such a weird conundrum because I totally agree with Judge Gold's decision, or Gull, or whatever, Gull, right? Like, I totally agree with her. I think those two attorneys are absolute, my opinion, are absolute slime balls and just disgraceful. Their actions, at least in this case, have been absolutely disgraceful, you know. And yeah, sure, it worked, you know. It worked. Their crazy behavior worked. And look at that, it's quietly frozen. Yeah, well, guess what? I'm going to quietly start getting frozen over here. Thank you very much. And look at that Boggle Queen from the past. All right. Quietly Frozen, the coolest name in YouTube history. How's my audio? I just have a little crazy little lavalier mic that connects over to this thing that goes onto my phone. I have a battery pack. This is kind of neat. Look at this. I cleverly put a Velcro strap to the back of a pad, you know, one of these notepads or whatever, and then just strapped it to the back just with a minimal wire sticking out, and therefore you can extend the battery power for a long time. God, I hate this. Just, I mean, what do you do? You know, what do you do tomorrow? You wake up in the morning. I mean, we're probably the last street they give a damn about. 9 people. That's what you don't want. You want it to be a transformer on a main road out there. Then they go, oh yeah, if we get this one fixed, we can help 3,000 people. Not, oh, you're on a cul-de-sac. Yeah, screw you. Hey, thanks, your gypsy. Well, here's what I'm hoping is that now Fran Gold will have that hearing that they didn't want to have. So bring back in all the different investigators that were looking into the leak, etc., and let them say what really happened there. And I think at that point, you're going to, you know, then it'll be what it should have been. And then maybe, I guess what the problem is, though, is now the fact that Goal is the judge, that's probably a problem now. Because she's already made up her mind. She wants them off the case. So how can it be, at this point, unbiased from her point if you do have that hearing? You get what I'm saying? Hey, thanks, Boggle Queen. Now, so these are all things that kind of concern me. I just agree with her decision. I think those two attorneys have been an abomination in this case. But yeah, it was really interesting to watch. I would actually be playing it for you right now, again, if I had the ability to do anything. I mean, I guess, is that possible? Could I go to YouTube on here? Let me ask you maybe you guys can tell me what this sounds like. Thanks, WNC Granny. How about we look up some stuff first, though? Hold on. And I do have this at my computer. We could listen to the audio. I mean, that's really all it really matters. There's nothing amazing about the... let's see. Let's see. So it's, of course, they always put the murder sheet in there as if they're just bastions of incredible knowledge. The Indiana Supreme Court on Thursday granted Delphi murder suspect Richard Allen request, and they made this decision in like an hour. I mean, they had this whole hearing. They go, we'll try to get back to you guys as soon as possible. And an hour later, boom. Because that means that, the rights of the accused trumped any sort of, and that the fact that he still wanted those attorneys, even though they, I guess it's not what the Indiana Supreme Court is saying is it's not up to the judge to tell the client who is in their best interest, right? If the client wants somebody, then they want somebody. That's what they get to have. However, in this case, since Judge Gould removed them originally for, ineffective counsel of how they were doing things, then Richard Allen then says, I want them back. I think that should make it so that he cannot, use ineffective counsel ever again in any appeals of any kind whatsoever. Ever. Okay? Does that make sense? Hey, there's Cindy Lean with the crazy ass comment yesterday. Boy, another one. Never ends. The Indiana Supreme Court on Thursday granted Delphi murder suspect Richard Allen a request to reinstate his original defense team, but denied his plea for a new judge. Man, that's crazy. So I think what they're saying is, you didn't do it right. You should have had the hearing. I think that's what the Supreme Court is actually saying is, you needed to have the hearing to make a decision. So I think what's going to happen is, now they're reinstated, they're going to have that hearing, and it'll probably be really quick here. And I hope they do the same thing, have a live feed like that. That'd be awesome. Yeah, so the ruling came just hours after the justice heard oral arguments on the controversial case. The order did not state reasons for the court's decision, but said they will be revealed in a written opinion to be issued soon. The argument Thursday morning before the state's highest court came down to these key questions. Does Allen have the autonomy to choose his own defense? And did special judge Frances Gull abuse her authority when she forced Allen's attorney, Andrew Baldwin and Bradley Rosie, off the case after determining they had been negligent and incompetent? Mark Lehman, who represented Allen in his... Jesus. Some ad popped up right where I was reading. Who represented Allen in the bid to get his defense attorneys reinstated, argued the answer is unequivocal yes. No Indiana court has tolerated a trial judge removing a lawyer from a case over the client's objection. See, that part is always something that was a little bit bothersome. You know, that he really wanted them, and then he'd say that they'd even against his wishes to have the attorneys of his choice, she wouldn't let him. And so I think they should have had the hearing, and then she ruled on it. Then I think there'd be different information available to this panel, because I don't even think they were looking at that information very much in this decision, because it's kind of more narrow than that, I guess. Let's see. And it says, Gull's attorney, Matthew Gutwein, argued the judge has the authority to remove Allen's attorneys for conduct she found troubling. He also denied Gull has been unfair to the defense. Saying a judge's adverse rulings are not enough to show bias. Allen is awaiting trial for the killing of Abigail Williams and Liberty German. Yeah. All right, and they also said that they wanted to have the trial in 70 days. I remember that. That's crazy, huh? I mean, what do you guys think of this? This is insane. And of course, all the trolls showed up and go, "You're wrong, Grant. You're wrong." No, I still believe that her removing them was the right thing to do. Now, I guess apparently, I mean, the Supreme Court overruled her opinion, right? So I guess, what is the right thing? What if the Supreme Court came in and overruled the Indiana Supreme Court? Does that mean that Judge Gull was correct originally? Or is it just really kind of an opinion, and that's why you have Supreme Courts and things like that? What? It makes me look younger. What do you mean? Hey! Well, maybe it's because my, look at, watch this. Hey, I'm an elf. I'm not sure why I just did that, but why the hell not? Oh yeah. Yeah, like the, hey, a blank slate, what's going on? Yeah, I had this really cool thumbnail that I made. I was just about to go live like in 10 minutes, an hour and a half ago, and then it just went right as I was trying to hit the save button. It was just unreal. Maybe I can try to, if I open up YouTube, I can play the audio if you guys want. Let's see. There it is.
Choose from a whole library.
Hey, it's Mag too. Wow, this is this is like a reunion.
And his license count.
This is like a freaking reunion in here. Quietly Frozen was in here, Mag. Can you believe that? And Caligal 3 popped in again. Yes, indeed. I did the whole story. Hit the rewind button and listen to the very beginning. There was no wasted time.
January, and to have a well-developed strategy of third-party guilt. These lawyers knew what
were disseminated and made it, and I turned off the stream. Okay, do you guys want to listen to this maybe, or
based on the judge's subjective belief?
I guess we could pause it here and there.
And I have the link again over here just in case.
Can you guys hear this pretty good? Listen.
But you guys don't forget.
Let's see.
We'll
Right.
be arguing first. In a council table, we also have Chris Stake,
Can
who's
you hear
also
that?
here on behalf of the respondent. Correct. Good morning and welcome, Mr. Stake and counsel. Counsels, we've been conducting oral arguments. You'll each have about 2 minutes before we may start asking questions.
All right, I'll say it again. At about 1:40 or something, I heard just bang outside, and this huge tree fell down from my irresponsible neighbor's home, the ones with the chickens. They have these huge overhanging branches. They never do anything. It landed right on my power line and their power line, and somehow mine survived and stayed up on top of my carport and then went over to the house. So I don't know if the carport itself, I don't know, man. I don't know how electricity works like this. But anyways, theirs broke off their house and the wire was in the middle of the road. And so mine still had power for a long time. And then a little bit later, the ice got on these trees on the across the street. It had nothing even to do with that. And got on the power line. And I think it broke. I think the transformers are sort of like a breaker. I mean, that's my, just layman's opinion. And it went boom, just like an hour ago, and lost all power in the house. So we're screwed. So there you go.
Each side has 30 minutes. So you ready to proceed?
I am, Your Honor.
All right, Mr. Lehman.
They are half-wits. Yeah. This is weird, though. It's working. Here, look at this. I can almost go like this. That's what it looked like in there. It was cool.
Morning, Justices. No Indiana court has tolerated a trial judge removing a lawyer from a case over the relationship, over the client's objection. The integrity of our entire judicial system is undermined, and the lawyer is negligent.
There it is. That's what it looked like. All right. Did I hit something? Oops, I think I must have done.
Asking questions. Each side has 30 minutes. So you ready to proceed?
I am, Your Honor.
All right, Mr. Lehman.
Yeah, you guys can all watch it back on the channel later if you want. But we had all these trolls showing up. You're wrong, Gray!
No Indiana court has tolerated a trial judge removing a lawyer from a case over the client's objection based on the judge's subjective belief the lawyer is negligent or being ineffective. Cases across the entire country do not tolerate the removal of the entire defense team from a case over the client's objection where the lawyer is licensed in the jurisdiction and prepared for trial on the scheduled date. When a judge severs the attorney-client relationship over the client's objection, the integrity of our entire judicial system is undermined, and the unauthorized action necessitates that this court intervene and invoke its inherent authority to supervise the conduct of lower courts. On October 12th, the judge ordered counsel to, quote, cease work on Mr. Allen's case until we meet on the 19th. This was a period where...
Hey, I want to say thank you to everybody who sent in super chats. I can't screen so little on my phone over here. It's hard for me to thank every single one of you, but I'll do it on the next show, okay? I really appreciate it. Thank you. Yeah, you can join the reunion, Lisa Holland. There you go.
Intensive work was occurring in the case where Mr. Allen and his lawyers were in the middle of tactical decisions and strategy review. This impined the right to counsel. When October 19th rolled around, the judge took clearly coercive action to sever the attorney-client relationship on her own motion. The judge was without jurisdiction to sever the entire defense team over the objection of Mr. Allen's wishes, and his licensed counsel, who both remain in active and good standing in our state.
Without jurisdiction?
Can you guys hear this? I mean, it was pretty cool because they were like, "What do you mean with that?" They would just the Supreme Court is really cool how they just they're basically having argument with somebody to make sure that they can prove all their points, and they're like, "What do you mean without jurisdiction?"
Explain that. Why was the judge without jurisdiction?
Judge, I think the judge here exceeded her jurisdiction when she refused to accept Rick Allen's wishes when she had an absolute duty to act upon them. And the judge crossed the barrier of neutrality and entered the realm of being an advocate. And when the defendant is saying, "This is what I want, this is what I desire," that the judge is without jurisdiction and has an absolute duty to act upon the client's wishes under those circumstances.
So isn't your argument more accurately phrased that she's under a duty to let them back into the case? It's not a question of court's jurisdiction being exceeded, is it?
No, Judge, I see those as one and the same.
Are you talking about authority or jurisdiction? I mean, we have a lot of cases that define both of those differently.
Judge, I think that under either construction, and I see this as the judge is without...
Yeah, so it's not like jurisdiction, if you're not talking about authority, because some people think the word jurisdiction means authority, and then some people think it means like the area, like her ability or her rights to do something, the judge. And so he should have listened to that and said, "No, I just mean that." He should have went with what they were trying to tell him to say. But he worked out. He's the one that won anyways.
The judge is under an absolute duty to act.
No, I already read that.
Of the defendant.
I just read that earlier that the judge goal is still on the case.
Under these circumstances.
Okay, but you don't cite a lot in that. So when you talk about absolute duty, a court, we have cases that say courts can remove counsel for various reasons if they're not a member of bar, if there's a conflict that really is to the detriment of the client. So there's not an absolute duty to always leave counsel on, correct? There is some discretion that the trial court judge has.
There's an absolute duty to follow the client's wishes, and when a conflict of interest arises, the issue is whether the client fully understands that whether he's making a knowing and voluntary decision.
And the absolute duty is found under the Sixth Amendment?
Judge, I think the absolute duty could just be under this court's case law, but I think that in the aggregate, that the three violations of the Sixth Amendment provide this constitutes three situations where in their totality where they clearly placed a limit on the judge.
Is there a reason why you didn't file a state constitutional claim? I was sort of surprised by that under Article 1, Section 13.
Judge, we didn't feel like we had the record to preserved that issue and developed a separate argument under the Indiana Constitution. But we're not arguing that this court isn't free to proceed under that analysis. We had basically 5 or 6 days under a situation where the judge wasn't even giving us a transcript to see exactly what took place within that
You have a lot of concerns, but I've got a couple. You've got a lot of concerns, and you do a nice job laying those out in your brief. But there's a couple things. You're asking the court to issue a ruling for a speedy trial. It appears Mr. Allen signed that with his attorneys in August, but they had never filed it. So, correct?
Yes, I think when he signed it, they were outside of the 70-day, but the speedy trial...
But you acknowledge that you're asking us to grant something that wasn't requested at the trial level.
Well, it wasn't requested at the trial level, Your Honor, because it wasn't necessary until October 31st when the judge removed them the third and kind of final time.
So they sat on it they had it for 2 months and didn't file it. Your client signed it in August under the...
Yeah. Yes, Your Honor. They had it and did not file it. One, there wouldn't have been a reason to file it. They had it made. So the speedy trial was an intimate part of their strategy here, and they had developed strategy and tactics with Mr. Allen as to when specifically to file that. The request for the completion of discovery was granted by the judge. That deadline was submitted or ordered by the court to be November 1st. And then the tactic that...
Yeah, one thing I said on the previous show was it's sort of interesting that they want to have a speedy trial now within 70 days. And it's also concerning there's one thing that if true, is concerning to me, is that in Richard Allen's current prison, if they're continuing to eavesdrop and trying to hear what he's saying to the attorneys, it makes me nervous that they're trying to do that because they haven't really buttoned up everything. You know, like they're still looking for some sort of nugget other than him confessing already. You know, I'm trying to figure out, why would you need to continue to, if it's true, like they're trying to record all of his meetings with his attorneys, et cetera, et cetera, et cetera. Why would you be doing that? So that's bothersome to me.
There would have been to file for a speedy trial right after that to lock in the trial date and to close down the evidence that the prosecutor can then introduce at that point. But Your Honor, that request is because it's the relief that our client wants, and so we needed to present it to this court.
See, this is opposite of the Idaho 4 case, where after they saw the writing on the wall, they went, yeah, we waive our right to a speedy trial. And the prosecution, I think, is done in that case. They're just waiting. Okay, yeah. This is dead to rights, you know. Where in this one, I mean, who knows, right? I mean, it took so long to stumble upon Richard Allen again after all those years. But there could be a couple aces in the hole, you know, perhaps even family members in the Richard Allen case.
Obviously, if this court reinstates attorneys Baldwin and Rosie and orders the judge off the case, that if we proceed forward with the trial, that they can refile that with the senior judge who would take over the case. But the relief that Mr. Allen wants is he wants...
Do you think these lawyers did too what? These lawyers were garbage. They were absolute...
attorneys Baldwin and Rosie on that case, and he wanted a speedy trial. And in order to show...
In my opinion, of
that's
course.
an intimate part of the trial tactics and decisions that were going on, was to present that to the court and make sure that this court had an opportunity to rule on it if it wanted to do so.
Does your argument depend on our having found that the trial court's underlying findings of gross negligence and incompetence were wrong?
No.
Well, if she's right about those findings, why isn't the relief that she ordered appropriate?
First, Justice Slaughter, she's not right about those findings. Second, there isn't a record to even substantiate those findings.
Yeah, one thing I think is kind of odd is, didn't Richard Allen's attorneys deem him incompetent? Didn't Baldwin and Rosie say that Richard Allen was almost kind of crazy right now? Like he's almost incompetent because he's been, you know, treated so strangely. He's drooling on a shirt. How is he capable of then saying, boy, I think my two attorneys are great, I want to keep them?
But third, those issues don't
if
involve...
If there's not a record, maybe then the findings aren't proper. But if the findings are correct, why doesn't what she did follow from those findings?
Because the client has the autonomy to choose the direction of his representation. And if he is aware that there may have been some sort of violation, or the judge feels that there's a violation, he is allowed to waive that concern and to proceed forward with the...
Maybe, WNC Granny, maybe.
For example, she's concerned, at least as I understood the record, she's concerned that with these counsel proceeding on his behalf, if they go to trial, he may well have built-in reversible error because his counsel are ineffective, constitutionally ineffective. And if you're talking about a waiver of rights, are you suggesting that your client would waive whatever Strickland violation might occur were he to proceed to trial with these lawyers?
Judge, that's almost essentially what happened with regards to the disclosure of the Westerman materials. He filed with the judge, says, I'm aware of that. I know what's happening. I'm ready to ride and die with these lawyers.
I'm just asking you to tell us on the record whether that's something you're asserting on your client's behalf. If we grant the relief you want, there will be no Strickland claim that can be asserted because you're waiving it.
I think on the if the judge was to build appropriate record, that can happen. The judge, that's what...
See, that was awesome. See, that was amazing. That Indiana Supreme Court Justice right there, he said, I guess they're like, Strickland must be something related to ineffective counsel. And he said, well, listen, they were just removed because Judge Gould said that they were ineffective. So is your client now waiving the right to use that as an appealable issue later? Because if we grant him his attorneys back, because he's basically, I think he's waiving the rights to claim that they are ineffective because he is now taking back who Judge Gould deemed to be ineffective. Do you get what I'm saying? And let's see, he's trying to worm out of get an answer. Well, I think that's what they said with the Westerman thing. You know, he took him back even after the Westerman.
Happens in all conflict of interest cases, and that's what happens under this court's case law. You bring the defendant into chambers, and you say, listen, in Lada, he's representing the wife, he's representing you, he's representing your husband, ma'am, and he's representing you. Do you fully understand that by proceeding forward, that could cause some problems for you? And he may not have fully disclosed those to you because his interests, his loyalties are divided.
Well, if I hear what you're saying, you're invoking your client's right to counsel of choice, but you're disclaiming your client's right to competent counsel if and when he goes to trial.
We don't need the play-by-play.
Disclaiming, no.
You're waiving your client's in willingness or right to invoke a Strickland argument on collateral review.
The client can knowingly and voluntarily waive conflicts of interest, and he can waive certain issues for collateral review. Absolutely. But none of that happened here because the judge didn't hold a hearing. The judge didn't hold a hearing and say, listen, I feel like this pretrial publicity somehow a year ago is going to contaminate your trial.
Counsel, we're not talking about waiving conflicts of interest. We're talking about waiving ineffectiveness.
Yeah. None of these things that the judge is citing have anything to do with ineffectiveness of trial counsel at trial. Ineffectiveness is not coextensive with ethical violation.
She thought his representation was grossly negligent and incompetent.
She said you're grossly negligent and incompetent. I don't know if it was about trial representation at all. And in the arguments that she advances in the brief regarding what she says is grossly negligent and incompetent have nothing to do with whether a fair trial is going to happen here. And if there was a hearing where these matters were discussed and fully vetted, that either the client could waive any Strickland issue as to those issues, or the issues would be proven that the judge there's no foundation for the concerns that she's had.
Mr. Lehman,
Yes, Judge.
that's really what I'm struggling with. Our original jurisdiction is very limited. And so if we were to agree with you on the substantive arguments that you've made, why is it that the regular appellate process is wholly inadequate?
Yeah. Justice Goff, interlocutory review and direct review are impossible and don't get us anywhere near the relief that my client's entitled to. My client was entitled to a jury trial today. My client's entitled to a jury trial with effective lawyers that he spent a year and 3 months developing a well thought out strategy of third-party guilt and a speedy trial to catch that prosecutor.
Are you there? I think we might be back now. Something that was weird. So he said he wanted to catch the prosecution on their back foot, and so that sort of makes me wonder again about like why they were recording in prison, right? It's pretty crazy.
And that interlocutory review process by putting a motion in front of the judge, asking her to certify an order that we weren't even sure what her order was, but she wouldn't give us the transcript until we came to this court and insisted that she get it to us so we could figure out what the scope of what happened was. So she would have had 30 days to rule on that interlocutory request. Meanwhile, Ms. Winicky and I got this entire case briefed on an original action to this court in less than 30 days with amicus filings on all parties. And that was even with the judge asking for an extension of time. This gentleman had attorneys Baldwin and Rosie, who he'd been working with for over a year to develop and get ready to catch that prosecutor on their back foot with a well-developed third party.
Well, that's why they said he was drooling. Yeah, because he was crazy when he gave that confession. He was just, his brain wasn't working well. But it miraculously got better again when he decided he wanted to keep his attorneys. It's weird how the timing of that.
Guilt strategy that was to be going now.
Wait, Mr. Lehman, we would have a full record if they hadn't agreed to withdraw, correct? It would have gone to hearing?
I don't think they would have had a full record even then, Judge. The judge was saying that there There was a coercive action of the judge. I'm going to go out there and I'm going to say these things. And Mr. Rosie presses at her. Well, what's that proceeding going to be? And the culmination of it is, that the judge says, the culmination is you're removed. So the record, I don't know, would have been any better. And in fact, it would have harmed Mr. Allen even more, because it would have put on the public record the judge's personal bias towards the strategy that he had developed, which is a strategy of these two gentlemen.
That's one of the things you have to prove with regard to the request to recuse.
Well, we believe,
because you're saying there's not enough for this, but there is enough for that. There's not enough information with regard to the negligence and incompetence, but there is enough with regard to personal bias.
Correct.
I think Judge Goals, the only thing that she did wrong, in my opinion, was that she didn't hold that hearing in public that day. Had she held it in public and then made her ruling, there might be a whole different, you know, the Supreme Court here would have different information. It would, you know, and then you see how things went, and then rule on it. But the way it came out was that she already made up her mind and was just going to have a public flogging, basically. And if you're out there, if you want to help support the Grant Hughes Investigates YouTube channel, doing shows like a mailman in the sleet and snow, I'd appreciate it. Thanks.
Your Honor, I don't think those positions are inconsistent. That there is no evidence of incompetence, certainly no evidence of trial incompetence, which is what the 60
my concern is getting this case back on track.
Yes.
All right. So your argument is that you have a constitutional right to counsel of your choice in this circumstance, and you acknowledge there are some circumstances that you do not. And if this case would go to trial, if there was a conviction, it's structural error, it'd be reversed, and everybody would have to go through this again. Correct?
Yes. Judge, but I do want to clarify that this is more than just a choice of counsel case. Like, this is interference of counsel. This is the right to counsel itself, because the right to counsel is meaningless. If a judge can say, stop all work, I know you've got a relationship going on, stop it all till you come to my chambers, and then says, you're off the case, whether we go into the courtroom or you stay in here, you're off the case.
There's a lot of events in this case that led up to that hearing, correct? With regard to sending information on a case to another criminal defendant, with regard to, well, there's a lot. I'm going to go through it in both your briefs. So there's a lot of...
I'll finish it for her. These are the same things I mentioned last night. And then releasing a document that was supposed to be in the gag order with the Odin information, intentionally releasing it. I know that was intentional because I knew that it was going to be released 2 weeks before it was released. So, and it was released, and therefore it was done intentionally, and only a few certain people were let to know that it was going to be released, and boom, they were able to download the documents and make it public so that their client could have this, get the crazy psycho conspiracy nutjob people in society on their side. And there's tons of those people, especially on social media. They languish there.
Questionable things that have occurred up to this point.
Hey, thanks, Tony Lee and LN.
Discovery or letting third parties have access to discovery. Is there no line that a judge, let's say that everything was turned over and counsel didn't show up for hearings. Is there ever a line that a trial court judge has to say, listen, I know this is your court, at this point, a court-appointed counsel. I do not think you're going to be fair. You're going to set yourself up on the flip side for reversal, just like I talked about the structural error being grounds for reversal the other way. You're going to come in on a Strickland ineffective assistance of counsel and say, my attorneys were not effective. I mean, I lost. This is because my attorneys did X, Y, and Z.
Yeah, the not showing up for hearing is a unique situation, because one is the lawyer's not being a lawyer at that point. They're not
filing briefs, not meeting deadlines, not submitting a brief of AI that doesn't make any sense.
So, Judge, if a judge is exhausting other remedies short of disqualification, extreme misconduct will eventually fall into one of our other categories. That is, the client will object to the continued representation. The lawyer will be removed from the case. The lawyer will eventually himself pull out of the case, or a conflict of interest will develop. And we see that in some of the other cases across the country. And so, like, if a lawyer in one case was obstructing justice, he was literally going behind the scenes, talking to co-defendants who were represented, trying to manipulate their testimony. The judge at that point would just proceeds forward with the law on conflict of interest. It says, calls forward those witnesses, said, did this lawyer try and obstruct justice? Did he try and commit a crime? And then at this point, a conflict of interest occurs, because then the lawyer can't admit the defendant to take a plea because for fear he might himself be more criminally culpable.
But you believe that all conflicts are waivable. Am I understanding your position right?
I think that our rules that an actual conflict of interest is unwaivable when you sue one party versus the other, and shockingly, that seems to have happened in one of the cases in Indiana. So I think, but other conflicts are waivable conflicts, other than that one rare exception of.
And I'm still a little confused with the exchange with Justice Slaughter about the waiver. So let me if we grant you the relief you're requesting, we reinstate counsel, and Mr. Al's convicted, can he pursue through PCR, post-conviction relief proceedings, a claim his counsel were ineffective for the very same reasons
there you
the trial
go.
judge here found?
So the trial judge here found that he can't, it depends on what record the court would build regarding those, but no, I'm going to change that, just no, because these issues have nothing to do with effective representation at trial. So I don't think he could pursue them on those grounds.
No, they weren't forced out.
So I don't see how these three violations, the inadvertent disclosure.
They weren't forced out. They chose not to have a hearing. Yeah, that's when people don't really understand. They were not forced out of there. They didn't want to have a hearing. She was going to remove them and gave them a choice to either leave the way they left or have a hearing. So I guess if you're saying that she was going to remove them anyways, yeah, I don't know. I don't really know how to look at that. Maybe.
Pre-trial discovery that the press release go in direct response to press that the government was putting out. I don't see how those issues affect his trial. So I don't think he gets a post-conviction relief through that, because those issues don't affect trial strategy.
But you're saying he would lose on the merits. You're not willing to concede that it would be waiver, and it seems odd that he could have it both ways. That he
You know what I think is strange is all of the the pro Richard Allen wackos out there. They don't ever look at the just horrendous things that they did. Like Darling there. Like what's strange about it is like, don't you get it? I mean, first of all, they're so lazy and just sort of whatever. They gave another criminal some ridiculous information. They sent him case information. Then they put out the Odin document intentionally. Then they allowed another person to come in and, if you want to believe their story, took pictures of crime scene photos and leaked them out on the internet. And at one day they will make it out there. Okay, they will make it out there. I guarantee it. Right. She was trying to help their reputation. But it's weird how they don't even think of those things. These pro Richard Allen wackos. Like, you don't think that is absurdly trying to just gross, I don't know what you call it, just violation of the judge's orders by putting out a document, letting a few bloggers and, podcasters know so they can hurry up and download the document, and then, oh, wait, sorry, this was against the gag order. I mean, give me a break. That is so far beyond anything rational. Man, you guys are embarrassing if you think that's okay.
can say you can never remove my counsel over my objection. I object, but then still have available to him the argument later that, well, even though I objected, it was still ineffective.
If the judge exhausts, I think the judge can take care of that. The judge can call, say, let's have a hearing regarding that pretrial publicity and somehow establish that might be affecting his trial and that it fully and fairly advised.
Hey, Cindy, come on. You barely know the case, okay? You come in and you're always acting like you're the expert in the room, okay? Just kind of listen, figure things out.
Advise him that that's a repercussion. But when he's fully and fairly advised of the repercussions of that judge's subjective belief that there was somehow some sort of ethical violation there, I think that he would be waiving it. So,
Counsel, are you arguing that the record doesn't support a finding of ineffectiveness by the trial judge, or are you saying If
There's
the
this
judge
guy right
finds it,
here.
she still can't remove them.
Oh,
There's that one.
this record does not support ineffective assistance of counsel.
But even if it did,
No,
Thanks, Ivan.
sorry. The reasons that she advances aren't reasons to find a lawyer ineffective. Now, if this court was to say those are reasons that a law that would constitute ineffective assistance of counsel for a Sixth Amendment violation. So if we were to get to that point and he was fully and fairly advised of the potential repercussions of those violations on his trial strategy, then you could have a waiver issue. But the reasons that she cites for doing what she did have nothing to do with trial. But let's assume for a moment that she cited a reason. There's an intimate relationship.
Well, that's what they're trying to get them to say, that on record, make sure to, say that you can't use as the ineffective counsel now that it seems like Richard Allen should be waiving his right to ever claim that Baldwin and Rosie are ineffective because they've been deemed ineffective by Goal, and he wants them anyways.
Going on. And she pulls them in and goes into the chambers and says, listen, I understand that there's an intimate relationship occurring between the defendant and you. Do you understand that's a conflict of interest? That's a violation of the ethical rules, that there's a disciplinary proceeding that I'm going to be referring for him. Do you want to go forward with this representation? And the client says, yes. I think we've got a waiver of ineffective assistance of counsel on those grounds, but I don't think that the judge is absolutely precluded from injecting herself and saying, well, in that case, it would be a conflict of interest. So we're struggling to find a situation where there's an ethical violation that affects the outcome of trial, where there's a situation where the defendant says, I want to go forward, I've been fully and fairly advised of it, and the judge somehow has a role, absent the conflict of interest, injecting herself into that. And I do think that you can waive an ineffective assistance of counsel claim. That's established case law. It's just none of these things the judge cite have anything to do with ineffective assistance of counsel. These are purported ethical violations, and not every ethical violation necessarily, even if it was established, has anything to do with trial strategy and whether a defendant receives a fair trial. And these are examples. These are good examples of that. In that the inadvertent disclosure of pretrial discovery the alleged violations here would have nothing to do with the trial strategy that attorneys Baldwin and Rosie developed with him, and would have no impact on that case.
Mr. Lehman, let me just sort of ask with respect to the line of questioning, if we were to agree with you and find that there was inadequate reason, at least on the record, to allow for the removal or the refusal for counsel to reappear, nothing would stop the trial court from making a more complete record and going through a different process if in fact it believed that there were sufficient reasons to remove them. They just weren't adequately reflected in the record.
Judge, I think a court has broad discretion on how it conducts proceedings in the courtroom, but none of the reasons that she cites in her brief would allow would even if found, would substantiate the removal.
But if the court were nonetheless worried about the finality, the eventual finality of the proceedings, and wanted to nip a problem in the bud, is there anything that would stop her from conducting a proceeding on remand or similar to prevent
No,
that?
I think if there's a concern, say, for example, the pretrial publicity, the press release, if you say, listen, I think, because the violation says it has to affect the fair trial. So, okay, you're going to have a hearing. The judge can.
I think the press release is that Odin document. That was a huge thing that I think puts them in like egregiously unethical when they did that. So I hope Judge Gold does the same, a hearing right after they're added back, and then next week do another hearing again. All right. Except that's where the conflict of interest comes in, because we already know what her opinion is. So is she able to then rule again and remove them again, and then we're right back here again? You know, it's crazy.
Have a hearing. Let's provide proof or get some sort of sense as to how this is affecting.
Wait, hold on. Signaling. I'm signaling everybody. Ooh, hold on.
But if the client is fully and fairly aware of those proceedings and still wants to proceed forward with these clients, then the judge has an absolute duty to accept or to act on his wishes.
Counsel, I want to. Is it your belief that if we deny the extraordinary request that you've sought today, and the case goes back to trial with a different set of lawyers that this defendant just does not want, that there is built into that record
Oh, God.
at least
I can't get
fundamental
the
error,
phone.
maybe structural error that's reversible?
Trials for show. It's practice only trial, Judge. I think, and that's why we came here as fast as we could. Because if we do not get something done now, the victims are going to be hurt, the public's going to be hurt, the entire Indiana judiciary is going to be harmed because this trial's been pushed off till October, and when the judge said it in October of 2024, one of the lawyers, I believe, even represented, he didn't think they were going to get that date either. Everybody's hurt, and we're going to delay things.
And you think the Gonzalez-Lopez precedent of the U.S. Supreme Court would dictate that outcome?
I think it's structural error, yes. So, and this trial is going to be for practice only, and we have built-in error, and the only way we can fix it and address the speedy trial problem, because that was an intimate part of the trial strategy, is to get attorneys Baldwin and Rosie back on the case and get this case set for trial in a time frame that's as fast as our law allows, which is 70 days. And that's what the relief we're requesting. Thank you very much.
Thank you, counsel. We'll hear from you again on rebuttal. Mr. Gutwein.
Now this is the Judge Gold's side here. I think this guy's pretty good. He got a little
Chief Justice Rush,
flustered
and may it
too.
please the court, I am Matthew Gutwein, representing respondent, the Honorable Francis Gull. This court should deny the petition for 3 reasons. First, the trial court to remove Mr. Allen's counsel was an exercise of discretion, and this court has uniformly held that a writ of mandamus will not lie in matters that rest with the trial court's discretion. Second, Mr. Allen's remedies on appeal are not wholly inadequate. The United States Supreme Court and Indiana's appellate courts have regularly resolved Sixth Amendment claims, such as those that Mr. Allen raises here, to the ordinary appellate process. And third, on the merits, in removing Mr. Allen's counsel, the trial court did not abuse the court's discretion. The trial court has significant latitude to prophylactically prevent a violation of Mr. Allen's constitutional right to effective assistance of counsel.
Counsel, is that really what's going on here? We don't have a great record before us on which to make these judgments, but reading what we have, I'm left with the impression that it's quite possible that 2 different concepts, ineffectiveness and insubordination, are being conflated here. There seems to be a great deal of concern by the judge that these lawyers were flouting her gag rule, and that they were insubordinate. But where's the evidence in the record that they are constitutionally ineffective? I mean, the order seems couched in that language that we're trying to protect the defendant from his own lawyers, but it's hard to look at this record and not get the impression that perhaps rightfully so the judge was exasperated with their conduct. But these are two different things, aren't they? Insubordination and ineffectiveness.
Under the United States Supreme Court decision in Wheat, the trial court, in exercising her discretion to remove counsel.
Yeah, here's one thing I could say. I never understood Judge Gold's comment about ineffective. You know what I mean? Like, that part was like, what does that mean in this one? To me, their behavior has been just egregious in terms of like unethical behavior. But were they effective to him? Like, you might say you didn't like Casey Anthony's attorney, right? A lot of people go, man, I hate that guy. But man, wouldn't you have loved him if he was one of yours? But I don't know if he did stuff like this, though, where he was going behind the judge's rulings, and he just kind of came up with this crazy strategy, blaming it on the father. Right? So I've never really understood the ineffective counsel part of it. And I guess that's what the argument right now is here.
Does not need to find constitutionally defective counsel. It does not need to require ineffective counsel. Rather, as in Wheat, there just needs to be the possibility of ineffective assistance.
But I'm really
of counsel.
struggling with that. I'm butting that up against the Sixth Amendment constitutional right to counsel. and particularly when they filed the second petition of filing as private counsel of their choice. That's structural error. And I agree, it is. Okay, you can shake your head, but I'm reading the Justice Scalia and taking him for his word on what that is. And how do we get this case back on? So we have that hearing. You have issues with regard to, well, you gave a press release. Well, the gag order was after the press release. You've got, well, we don't like, what you filed in, I think it was in June, with regard to conditions in prison. Well, most of those were wrong, but that means some of them were right. We have in the record now, because we can take notice there.
And I'd give my firstborn son to not hear you talk, Ivan.
There's a new motion to transfer,
especially with the Russian accent,
filed by his current attorneys. So we don't have hearing, we don't have findings. You've got a constitutional right to counsel, and he's choosing this counsel. You have a constitutional right to say, I don't want an attorney, correct?
Under Wheat as well as Lotta, this court's precedent, he does have a constitutional right to select counsel, but that constitutional right is highly limited, and that right may be outweighed by any number of interests.
But counsel, if you're a very, and I'm quoting Chief Justice Shepard in the Knox case, saying a judge has a very limited right to tell someone who their attorney can be. He just decided not to go with the parameters there because there was an agreement to withdraw.
Wheat says the other, Your Honor. Under Wheat, the trial court's discretion, faced with the balance between, on the one hand, counsel's right to select counsel, and on the other hand, counsel's right to effective assistance of counsel, is the trial court is to be given substantial latitude, is to be given wide latitude. What Wheat says is that decision is best left for the intuition and judgment based upon the experience of counsel in weighing those competing rights. Wheat says, in a highly deferential standard, that the issue of whether trial counsel should be removed must be primarily resting.
And I don't read Wheat, and I looked at Wheat several times as strong as what you're doing. And I think what you're doing is you're butting right up against a constitutional protection, and you're doing it at your peril. And this court would do it at this peril with regard to a case possibly having to be tried twice and having everybody going through that again.
Yeah.
That exists either way, right? In other words, as this court has already identified, if the trial court, if Judge Gull does not remove counsel, then counsel has the possibility of raising an ineffective assistance claim.
But isn't that a really good reason for us to just go ahead and address the merits? I mean, I'm a little confused why the respondents don't want us to address the merits. I mean, I realize you think there was no mistake, so why not ask us to just say that? And you're certainly right that we have plenty of cases saying in original actions we don't review discretionary issues, especially not issues of first impression. But I think I found at least 4 cases where we went ahead and did exactly that. We've looked at attorney disqualification issues, including issues of first impression. So why isn't it in your client's interest to just get an answer from our court one way or the other, whether this was error?
Well, I do think that it would undo enormous amounts of procedural law on original actions. I mean, this case has so many procedural hurdles, that Mr. Allen cannot scale based upon the procedural requirements. And I don't see how this court could exercise a limiting principle that somehow it's perfectly fine to grant the writ when this is a matter of discretion. The court doesn't grant writs for matter of discretion. There's a remedy on appeal. The court doesn't grant writs for remedies on appeal. They never specifically even asked for this relief in the trial court. The court doesn't grant writs. So I think you would be doing structural damage to your original action jurisprudence, and frankly then open up the floodgates, because these kinds of pretrial claims of constitutional violation are extremely normal. They are extremely rare. And if this court wants to get in the business of addressing the merits every time a criminal defendant raises a pretrial constitutional violation, you will be flooded with these kinds of actions.
So you're
Well, that's right, Cindy, because your comment last night, you're always so rude in some of your comments to me, and I've talked to you about it many, many times, and if you keep doing it, I'm just going to remove you at some point, okay? So don't be acting like, oh, he said I was drunk. You either had to be wasted last night, or just you're very dumb to type in the type of comment that you typed in, okay? I've told you about it 1,000 times, yet you can't seem to control yourself. It's really weird.
Well, you think that counsel's, Mr. Lehman's argument that no meaningful appellate right exists is just wrong from your perspective.
Well, that is absolutely wrong, and Hannah reflects that. Hannah is an interlocutory appeal on a claim for a violation of the right to select counsel, and on that interlocutory appeal, the Indiana Court of Appeals found there to be a violation and restored counsel. There can't be any serious question that these kinds of claims for Sixth Amendment violations of the right to select counsel are resolved on the ordinary appeal process. In fact, every single United States Supreme Court case to address the issue of the right to select counsel.
I can't see Cheryl's comments.
To the ordinary appellate process, and the Supreme Court had never so much as even hinted that the relief on appeal is somehow inadequate for a Sixth Amendment
And just
violation.
so clear, what you're talking about in the ordinary course would be a final judgment. He goes to trial with different counsel, he's convicted, and then you go up and appeal in the ordinary course?
No, not necessarily. I mean, there are interlocutory appeals, there are emergency interlocutory appeals, there are appeals after final judgment, there's appeals on PCR. And we have examples of all those cases. The absolute fact is that the ordinary appellate process offers a wide array of avenues for Mr. Allen to seek relief for his constitutional violation, and he availed himself of none of those avenues.
What about our 1982 precedent? So State versus Tippecanoe County. The shoe was on the other
sorry
foot.
about
It was
that.
the prosecutor's office that was disqualified in the
Sorry for the loss of your mom there, Cheryl. Like, it's hard to read these comments. They're so small. Sorry about that.
prosecutor sought a writ in our court. Now, we denied the writ, but we said that it was an issue of first impression. We reached the merits, and we gave the state the answer that it wanted through an original action.
Let me answer that in two ways. First of all, you've already identified this court denied the writ in that case. And second, there is no discretion for a prosecutor who has a conflict to prosecute the case. And in that case, the trial court had no discretion, had an absolute obligation to remove a prosecutor who has a conflict. That is not the case here. Under the United States Supreme Court's jurisprudence in Wheat, the decision to remove counsel based upon the possibility, based upon the potential for there to be...
But it has to be done, there's a way that you do it, and it does not appear this was done the proper way. You're supposed to have a hearing. The court did it sua sponte, which means on their own motion. There was a hearing in chambers. So did she exceed her authority by the manner that she presented them back in chambers, saying, you're either out or I'm going to publicly out you?
Well, there's certainly no U.S. Supreme Court case law or Indiana case law that says there has to be a certain amount of procedure.
So there's no process involved at all for taking a judge, no hearing, no, I have the suspicion that this is going on, I think you're incompetent, and you're out.
Well, the trial judge was prepared to have a hearing here. A hearing was scheduled. Counsel had notice of a hearing. The prosecutor was there ready to present witnesses. And the counsel in this case made their own strategic decision to withdraw rather than go out in open court and have a hearing. And that was choice. And they made that choice, I'm sure.
Having read the transcript, was it a full and free choice?
Well, these are very experienced lawyers. These are highly competent lawyers in other contexts. And they had notice that the judge was considering disqualifying them. They had notice on October 10th when the judge told them that she was considering disqualifying them. They were leaning in that direction. And between October 10th and October 19th, an awfully lot of lawyering occurred. On the 11th, Mr. Rosie got together with their client and drafted a letter. On the 12th, Mr. Rosie filed a highly detailed letter with the court offering his defense and asking not to be disqualified. Sometime before the 19th, Mr. Baldwin hired outside counsel. On the 19th... Yeah,
so they were all aware of this, but somehow they weren't ready to have a hearing.
Outside counsel filed a brief. They had oral argument. There were 9 days of an awfully lot of lawyering that occurred in that period. And at the end of that, what both counsel elected to do was state their intent to withdraw. And Mr. Rosie said, I've got a life outside of this case. I've got a life outside of this courtroom. I have a family. I have a law practice, and I'm going to withdraw. And that is his choice. That is his decision to do that. But if they had wanted, they could have filed for a continuance. They didn't do that. They could have gone out and had a hearing and presented evidence. They didn't do that either.
Would any of those actions have been non-futile? I mean, I thought the judge made clear that her mind was made up. She had prepared a script. She'd already made the decision. If they wanted a hearing, they could get it, but there was no opportunity to persuade her. Did I misunderstand?
We'll never know, right? Because there wasn't a hearing, because counsel elected to withdraw.
I do know, because she said that at the hearing on the 31st, what's changed? So,
see, that was the part right there when I was listening to it again. I was like, yeah. See, that's the thing is, if you're going to have a hearing, then shouldn't the here's where the goal's mistakes are, that she said that she already made up her mind, and she also didn't have a hearing. She should have had a hearing, knowing in her mind that she made up her mind, but not say that out loud and then just rule the way she wanted to rule after the hearing happened. Instead, she said, yeah, well, I'm going to read this and remove you, or you can just remove yourself first. And see, that was something that bothered me too. But I still agree with the fact that they were removed. That's the thing.
Thanks.
Well, we won't know what would have happened at a hearing that never happened. But you're right. I mean, I certainly.
Yeah, well, being honest is
there's
good, but
she probably wouldn't have changed her mind.
Counsel, I appreciate you.
Hey, thank you, Miss Moore.
Original action jurisprudence and our potential future caseload, but as long as we're here, what can you tell me? What can you point to in the record that supports a finding?
Here's
that
my
these
light.
lawyers were ineffective to the point where
little,
they needed to be
thin little light
removed
here
to protect
go like
the
that.
rights of Mr. Allen.
Again,
that
under
better?
Wheat, there doesn't have to be a finding that they were actually ineffective. What there has to be a finding of, and this is under Wheat, the potential to be ineffective. And here, it is not within the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material.
Can you help me understand how that hurt Mr. Allen's defense?
Well, believe Mr. Rosie.
See, that's the thing right there. It's the ineffective counsel part of it. How did the leaking of the memo helped Richard Allen? Doesn't everybody agree with that? It did, right? I mean, it helped Richard Allen because then all the wackos on social media, you've seen them all, they believe in it because it's such a cool story to dig into. So now there's this whole other segment of the population that thinks something else is involved. So it absolutely helped. So is that ineffective?
Mr. Rosie himself said the likelihood of public backlash is significant, and this leak serves no legitimate public purpose.
Yeah, but he said that probably based on the leak of the images. See, there's certain elements there. The leak of images might have a public backlash, the crime scene photos, but the leak of the memo absolutely helped Richard Allen.
The reality here, as we all know, is that we already have a polluted jury pool because of the inordinate pre-trial publicity that this case has garnered. And the further
There's the other light
of highly
over here.
confidential inflammatory material further pollutes that jury pool, making it that much greater to have a fair trial for Mr. Allen. And the trial court is rightly and appropriately able to exercise under Wheat, and I quote, intuition and judgment based upon experience, to find that if counsel is capable in the pretrial stages of making this many mistakes, manner and magnitude during trial,
I keep getting back to it, and I understand what you're saying, but I keep getting back to, if a criminal defendant has a constitutional right to say, I'm going to be my own attorney, well, that's fraught with more than just what we're talking about here.
You guys hear that right there?
These attorneys, and so we're spinning and spinning and spinning on this, saying delay and this, but he wants these attorneys. There's not been these findings.
Do you guys hear that sound right there? That was like a bunch of ice just falling on my roof and everything. I mean, who the hell knows?
With regard to incompetence, there's a lot of words out there, but let him have his attorney to get this case back. Let him have his attorneys. He wants to privately hire them. I'm really struggling with why he can't make that decision that's in his best interest and get this case moving again.
Let me answer that in two ways, Your Honor. First, again, in Wheat, the accused in Wheat, Mr. Wheat, knowing and intelligently waived the conflict in that case. And there was only a potential conflict. Wheat waived that conflict.
It was a major conspiracy with lots of different people playing, in the Wheat case. I don't see weed as tucked as neatly as you find weed. So go outside weed and give me something else.
Well, but again, Wheat himself claimed that this conflict was highly remote, highly unlikely to occur. Very small chance that the conflict will ever occur. And he waived the conflict, and yet the trial court found, based upon the court's intuition and judgment, based
But where can you point to me saying, with regard to saying somebody's incompetent or negligent? We have a string of cases. So these conflict cases have come up before with disqualification. Where are we on this?
Well, again, it is certainly not consistent with the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material that will pollute the jury pool. And here we already have a jury pool that is polluted.
Does that rule apply both ways? Because one of the things defense counsel said in their letter to the court was that they believed that the state allowed the dissemination of information regarding the crime scene. So can a judge disqualify the prosecutors too?
Well, again, the judge certainly could disqualify the prosecutor. We don't have any evidence in the record. We have Mr. Allen's counsels asserting that. There's no.
So that was a good sort of comment back by the judge there, and then this attorney got, whoa, I wasn't expecting that one.
There's never been a hearing on that. There's never been a finding on that.
I'm just trying to understand the scope of the rule and how sharp of a double-edged sword that this might be, that any leak of crime scene photos or anything like that can lead to disqualification of counsel on either side, I think is your position.
Well, Your Honor, our position is under U.S. Supreme Court precedent, as well as this state's precedent, this court's precedent, the trial court is vested with discretion. And even Wheat said that faced with the same facts, one court might find disqualification appropriate, another court might find it not appropriate. But because two courts could reach exact opposite decisions in matters that rest with discretion, doesn't make one right and one wrong. So I'm not suggesting, nor is Judge Gull suggesting, that there's an absolute rule here that every time there's an unauthorized disclosure, that gets into the discretion of the trial court.
You would agree the practical effect of the position you're advocating today will cause significant delays in this case going to trial?
Yes, I agree with that.
Does that have to be a factor in the consideration when exercising discretion?
It doesn't have to be a factor. It certainly can be a factor, right? The trial court, in exercising its discretion.
Yeah, I also wasn't comfortable with now it's a year later when the trial was going to happen, like pretty soon, like right around this time. Then all of a sudden now it's a year later in October. I thought that was pretty crazy. Hey, thanks, Jenny. Yeah. Well, I don't know if I can pay the bill with no electricity, but.
And again, Wheat went out of its way to say this decision can be based upon intuition and judgment, based upon experience, which requires less detailed findings, and it's a highly differential standard.
Mr. Gutwein, I guess more to the issue before us, when we're deciding whether or not the regular appellate process is wholly inadequate, how should we weigh the delay, especially when it's been asserted that Mr. Allen wants to exercise his speedy trial right?
Well, again, Justice Goff, as you already recognized, counsel never filed the necessary paperwork to exercise that trial. So that issue is, I would say, appropriate to seek relief because it doesn't satisfy the basic threshold condition precedent for seeking relief here.
Whether we give relief through an original action or we're concerned that there should have been more process afforded in this issue, a more full process with respect to the issue of removal. What possible harm could there be if we were to go do it the right way? If we're concerned about the eventual finality of these proceedings, everyone having to go through and do it twice, whether we reinstate counsel or we remand with current counsel and say you need to go through this process, wouldn't that save time in the long run?
Well, let me, perhaps, we don't know, but let me offer
that
this.
Protect everyone's interest in finality in the long run?
We really don't know what Mr. Allen wants. And it was not necessary for the trial court to hold a hearing to judge his wants because she was removing counsel. But if this court were to consider reinstating counsel, then the trial court would absolutely be required to probe his interest and make sure that he understood that counsel in this case had engaged in conduct that was detrimental to his interest, as counsel himself has already acknowledged it, and then see if he has a knowing and intelligent interest in having counsel continue, clearly on this record has engaged in conduct that's detrimental to his defense. I have exceeded my time, and so I will yield the remainder of my time to my good friend, Ms. Sanchez.
Thank you, Mr.
Your Honors.
Gutwein. Ms. Sanchez.
May it please the court. There's nothing clear or absolute about this case, the record, the proceedings that led us here today, the legal issues before the court, or the nature of the rights that Mr. Allen, counsel today, seeks to vindicate. There are means through the trial court and complicated questions. This court has repeatedly
Is the screen clear to you guys out there? Like, is this clear?
stated that those are the methods that are far more well suited to such complex issues. The appellate process, for example, would allow a full record in the criminal case, which we do not have here. It would make the parties to the underlying action the actual parties in this case, unlike here where the Attorney General's office is in the nature of something like an amicus, where in the...
Well, if it's not clear, you got to change your settings in there. Because if anybody out there can see it clear and somebody else can't, that's your issue, not mine.
Party of interest is the court forced to...
How about you, Daphne?
In defense of itself.
What would be the harm if because of the necessary...
But yeah, this is on a cell phone. So.
Backing up and going back through again, reinstating counsel, and if the judge is correct, then that will weed itself out, and there'll be a hearing, and it'll be done a proper way in the trial court, and then come back up.
Yeah, so that's what this judge is saying here. What if you just reinstated her, and then she has her hearing, and then does it the proper way? See?
The state shares the concerns, most especially the Attorney General's office, given our role in original actions, about this court's caseload and the increased use of that. But putting that aside, as Justice Bassett suggested, there are other concerns here. In this specific case, we agree that if any form of relief were to be given that included putting these attorneys back on, it would absolutely be necessary that further proceedings were had. On October 19th, when the judge warned the counsel of her intentions and her
Yep,
concerns,
thanks. This account you've typed in like 20 times now.
A hearing at which the state was prepared to present evidence that may well have been about an active investigation, evidence that may well be relevant to full understanding of the conduct that is
She's kind of blurry,
to the judge. Of course, the summary proceedings in chambers don't allow full challenge, full understanding and elucidation of the concerns. So a complete assessment of what is at issue here and the risks. The risk not only to Mr. Allen's representation at trial and his interest, but the entire risk to the process. Trial courts are not just tasked with protecting the defendant's right to effective counsel. They're tasked with protecting the entire proceedings and the fairness of the proceedings.
We all know justice for Abby and Libby.
For the integrity of the entire system.
A lot of people seem to have forgotten that, Abby and Libby are the, the victims here. And it's just sort of like this long... And by the way, there was this awesome case solved in Indiana from like 40-something years ago where 3 girls were picked up and by a guy in a, I don't know, it was station wagon or something, and they drove past where they were supposed to be dropped off, and both of them tried to get out. You know, it's sort of, I wonder how they knew that part, though. Sort of reminded me of that time when I was a kid. And then he ended up tying two of them up and then assaulting one and then killing the other two later. And then after all these years, forensic genetic genealogy solved the case. And I had it all ready to go, queued up, and, you know, found even the original story on it, and boom, nothing.
For the reliability of
No
the
power.
truth-seeking function and for
Do
the fact that everyone will...
Do you agree that with, under U.S. Supreme Court precedents, Gonzalez, if there's this mistake made in front of this case with regard to a defendant's constitutional right to counsel of his choice, that you can go through this entire process and have to do it again if there's a conviction?
Their state is concerned that if you look at what happened on the October 31st, and that is a very ambiguous series of events there, if someone were to conclude that what happened there was in fact Mr. Allen, it's a personal right to choose your counsel, he was in fact exercising it, and that it was wrongfully denied to him, that would be structural error. It is a concern for the state.
Yeah, well, it might not have power tomorrow.
Were
So,
to be the way that record was. Now, what's happening that day is itself another unclear and ambiguous thing. Counsel comes and files these appearances. On the face of them, they both purport to be pro bono, but also reassert the resistance to the rejection of the prior waiver and the desire to be reinstated as publishers, a contingent willingness to be pro bono counsel. Of course, the only knowledge we have of Mr. Allen is what he wants, what he knows, what he understands is, of course, secondhand. The choice of counsel is a unique aspect of the Sixth Amendment right. It's completely separate from the right to assistance of counsel, the effective representation, which protects the fair trial right. The choice is about your autonomy and independence. It's a personal exercise, and we need to know that Mr. Allen is in fact the person who was making that choice, that he was in fact competent to make it. There's been many consistent allegations about his mental state throughout the case, and then of course that he has the information he needs to make that as a knowing and intelligent exercise of a constitutional right under the circumstances, including the concerns about his counsel, the other options that he has available to him that he's choosing against, and so on. So, of course, none of that happened in this case.
Should we at least start with a presumption in favor of the continuity of counsel?
There is presumption.
Yeah, her answer here wasn't that good.
Something like it.
At the end,
Yeah, no heat,
desire
nothing.
of a defendant, the state agrees, to either retain his counsel that he's had is a factor a court has to consider and give weight to amongst all of the considerations at play when deciding how to balance all of the concerns for a fair trial, for his representation, to all of the other issues of efficient.
And then are you aware of any cases where attorneys have been disqualified on grounds similar to this?
No, Your Honor. In fact, there's a wide variety of cases around the country for various conduct that could be contumacious, violation of court orders, behavior during proceedings, or ethical violations. The trick here is that we find few cases that involve multiple different types of allegations, which appear to be what the trial court is raising, a pattern of behavior. But again, it's not fully explained because of the abbreviated proceedings below. I think it's reasonable when looking at if that is in fact what the judge
We just
means,
lost it earlier today again for the second time.
to have concerns greater about the prospective performance of counsel and the effect of their performance on the proceedings looking forward, if what the court was recognizing was a pattern of conduct that violated the rules, that tried the case in public.
This lady kind of just rambled on after she'd lost her train of thought and the question she couldn't answer it, and kind of rambled.
Not follow court orders, etc., etc., etc. where any one of those incidents in itself might not
But there's no other case out there where a judge sua sponte, on her own motion, disqualified based on her finding, her belief in incompetency and gross negligence.
There are cases of disqualification based on the court's own motion, and even in,
But for these reasons,
but-
could be
So I think what the deal is here is this would be like a precedent-setting, if not overturned, decision by Goal here.
conflict, it could be conflict, it could be.
So they don't want to.
the wording the judge chose is unique in itself. Another point that would help with the larger record to explain exactly what the judge means.
No, if you're adding them back, there won't be a second one is inevitable because it'll be the attorneys he wanted. That would avoid that happening.
Because of course we presume we're inferring from that choice of words and the particular thing cited by the judge what she meant by analogy to the use of ethical rules, the ineffective assistance of counsel.
Well, the leaked information is going to make it fair for, make it better for him, though. That Odin document helps him. So when you say it's not fair, well, they don't really care if it's fair, unfair in his favor, right?
Cases and so forth. But it's not the typical language.
Just so I'm clear,
Instance.
you've acknowledged the risk of structural reversible error if this defendant proceeds to trial with the new counsel that are now representing him. Despite that, the state's going to double down and say no relief today. Is that right?
No, we don't think it's there's no order, there's no absolute duty for anything to be ordered by the court. That said, the state does acknowledge that there are proceedings that can continue to happen. If Mr. Allen, in fact, is trying to exercise his rights, there just isn't prevented from doing so, even now.
Tell us more about that. What do you envision? If we go with the state's view and deny the writ today, what do you envision that might happen going forward that would minimize or eliminate the risk that we're talking about?
I assume my time's up.
Say by the bell.
You can answer that.
Well, no one wants more proceedings. There's no barrier to the filing of further motions. There was no barrier prior to bringing the original action, whether it be motions to clarify the prior orders and then to seek appeal from that, whether it be a motion seeking to exercise and specifically exercise his right to choice of counsel, and then if necessary.
I think this was just sort of like, let's let her have her first time in front of the Supreme Court situation. The first guy was very articulate, and this lady here was probably, wanted her first time to give an argument in front of the Indiana State Supreme Court. That's what it feels like. I don't know.
Appeal that. There is nothing stopping further actions and motions in the trial court and proceedings in accordance with that. There never was.
Thank you, counsel. Mr. Lehman, rebuttal.
Mine, 7 minutes
No, that's just how some people talk sometimes. Doesn't mean she doesn't know what she's talking about.
now.
It means that when you're arguing in front of the Indiana Supreme Court like that, those judges know everything. So they have all these questions that you might not have thought of, even if you prepared over and over and over again.
So, we don't know. All right, I'll go with it.
That's why they made it to where they made it.
Justices, I would like to begin by correcting the record. The judge says that we don't know what Rick Allen's wishes were, and the Attorney General says nothing is clear. On October 11th, 2023, Rick Allen filed the following. Dear Judge Gall, please accept this letter as confirmation that I have communicated with my attorney, Bradley Rosie, regarding the circumstances regarding the leaking of sensitive information.
He didn't write that.
I am aware that the images of crime scene photos and other documents were taken by a friend and former employee of Attorney Baldwin at Attorney Baldwin's office. I have discussed with Attorney Rosie the potential impact that the distribution of these documents could have on my defense. Attorney Rosie has also communicated with me that the prosecutor has requested that the attorney be disqualified from representing me in this case. I do not want this to happen. I want Mr. Baldwin and Mr. Rosie to continue to represent me until this case is resolved one way or the other.
We have that letter. We have
Well, the letter means he could appeal before they were added back. Okay, but now that they're added back, he can't appeal that same thing. These are back, everything's whole again. the trial, now there might be a hearing. I think Goal actually needs to now say she won't have that hearing to remove them again, because then that absolutely would end up being in a retrial at some point, because you would have a biased judge who already had removed them once, removing them a second time, and it just wouldn't work. So I think now that they've been added back, she needs to just go forward with it. That's just it.
Yes, it's on page 221 of the record, Your Honor.
Counsel, what if we end up agreeing with Mr. Gutwein?
Although I want to hear the hearing.
Court-appointed counsel, but we end up agreeing with you with respect to volunteer counsel. I just want to...
I mean, what she should do is have the hearing knowing she's going to keep them anyways, but have that hearing. So do the reverse of what she did the first time.
Make sure I understand the parameters of your requested relief. Are you only interested in having them reinstated as court-appointed counsel, or do you have an alternative request for their participation as pro bono counsel?
Our obligation is the defendant. The defendant wants attorneys Rosie and Baldwin to represent him, and he could not be more clear despite what the other side has tried to represent. But to do a half measure is to credit the judge and the attorney general for allowing this to happen. And because Mr. Rosie and Baldwin were ones who had an absolute duty to protect their clients' wishes, and they did everything they could to do that. To put them back in the case to say you're working for free, or that Mr. Allen needs to pay you, is to punish Mr. Allen and Mr. Rosie for doing what ethical rules require them to do, which is to give you due zealous advocacy for your client. And those gentlemen, when faced with a real tough call, financial tough call, career tough call, they showed up on October 31st and said, listen, our client, he's been clear what he wants. And this is what we're willing to do in order to protect his rights. But to say that they need to go back in and work for free, or that he needs to pay them, is to miss what happened here, which is the judge.
See, I think they need to be put back whole wherever they were prior. That's where they need to be at, paid by the state, be his attorneys, make everything the way it was, because now that the Supreme Court has overruled Goal, and then she has another hearing and then does the same thing again, man, that's just a shit show nightmare. Okay, so they need to be paid by the state just like they were before. That almost like we could just go back in time a month and a half or 2 months or something.
Had an absolute duty.
I mean, it's unfortunate, but that's just the way it should be, or this will be retried again.
His representation of what his expectations
unless he wins,
were, and that I want these gentlemen to see this case to its end. The Attorney General and the judge want to create ambiguity where none exists. We don't have records like this in other cases. This gentleman could not have been more clear on October 11th. There could not have been more clarity on October 19th. There could not have been more clarity on October 31st. And if your court looks at the new filings, where he also is waiting for this court to rule because he's confused as to who his lawyers are, we have some clarity here. And to do anything short of putting them right back in where they were when the rights were violated.
There you go.
So there you go. So we'll accept whatever the court's ruling is. But I think that alternative there falls short. With regards to Wheat says, where a court justifiably finds an actual conflict of interest, that's when the discretion kicks in. Conflicts of interest are different than these rules that the judge is citing here. Because a conflict of interest, the judge is complicit in the ethical violation because she has two appearances representing both parties in front of her. And they're different because we know that that's a situation where the lawyer hasn't fully and fairly advised the defendant as to what the repercussions are on proceeding forward. Absent a conflict of interest, we trust these letters like October 11th from these defendants. We trust that they understand what's going on, that they have cooperated with their lawyers and developed a good trial strategy and tactic to catch that prosecutor off on his back foot on a trial that was supposed to happen in January, and to have a well-developed strategy of third-party guilt. These lawyers knew what they were doing. They had articulated in 100-some pages of briefing. Here's what we see in this case. We're ready to go forward with trial. So conflict of interest doesn't apply, and that's what WEAK is clearly about. Conflicts of interest are different. And this court would be one of the first court in Indiana, for sure, if not the first court in the nation, to say that we treat all kinds of ethical violations like pretrial publicity or the inadvertent violation of a discovery order as something on the same level as Wheat's conflict of interest. That's unheard of, and this court should not be using the original action to create new law like the judge wants us to say here.
There you go.
Justice Masson, Justice Goff, and Justice Slaughter, you'd asked me a question about ineffective assistance of counsel. I'm clouded sometimes by my judgment because the rules that the judge cited here aren't ineffective. But absolutely, a defendant could waive a claim of ineffective assistance of counsel on the record, and that's what our conflict of interest case law establishes. If you pull the gentleman in and you explain to him what your concerns are, what's going on, and make sure that he knowingly and voluntarily knows what's going on and wants to proceed forward, yes, you can waive an ineffective assistance of counsel claim. So if a client wants to represent himself, he can waive his right to effective assistance of counsel if he knowingly and voluntarily says, I want to go forward and do this on my own.
We have 202 likes.
My troubles with answering that question is I feel so passionately, and Mr. Allen and attorneys Rosie and Baldwin feel so passionately that what the judge is talking about here is zealous advocacy, defending the rights of their client, trying to get this thing to trial quickly. And the reasons that the judge is stating in her brief, which are a little different than the reasons on the record, but none of those are what we see as being related to ineffective assistance of counsel, or would even, if proven to be something wrong, aren't going to meet the Strickland prejudice wrong. So, but yes, if these things could ever arise, the ineffective assistance of counsel and justices, I'm not conceding that, but if they could, hypothetically, yes, you can bring the defendant in and he can waive those rights. But that's not what we have here. In the end, Your Honors, the judge exceeded her jurisdiction and refused to accept Rick Allen's wishes when she had an absolute duty to act upon them, and there's an emergency that exists. I think when those things are before this court, there should not be a question as to whether original action exists. And there is more clarity than we see in records across this state as to what this gentleman's wishes are. They are undisputed. And I think that the judge had an absolute duty to recognize what he wanted, go forward with trial in January, and this case should be heard in Carroll County today rather than before the Indiana Supreme Court. But I appreciate your time and consideration. We ask you to grant the relief we requested. Thank you very much.
Thank you, counsel. I want to commend counsel on both sides. Just excellent briefing, excellent argument. We'll be discussing the case and getting a decision as quickly as possible.
Well, there you go. That was it. All right. So anyways, I think I got to get going here. Not sure who. Somebody must have helped out again up there. Anyways, thanks. Oh, there it is. Caligal 3 again. Golf needs to recuse and fly away. She messed it up too much. Yeah, I mean, the thing is, she either needs to step down or if she... But here's the thing. It's going to be tough to not... Now every ruling that she does against the defense will be looked at as bias. So it's hard to sort of unring the bell of perception, you know. She removed them, I think, rightfully so. My opinion is they deserve to be removed, but she didn't do it the correct way. She didn't have the hearing, and then made it clear that she already had made up her mind before the hearing would have even taken place. So it would have just been a public lashing, and so that wasn't good. But I agreed with her removing them. But now that she's still there, and Rosie and Baldwin are back on, and now she has the hearing and then removes them again, then he's going to get a second trial if he's found guilty. There's no doubt about it. If she keeps them on, it makes it hard because now anytime she makes a decision against them, the people are going to go, wow, so look at that. Look how biased she is. She should have allowed that. Then there'll be arguments on every single decision that why didn't she let this in and that in, et cetera, et cetera, et cetera, right? So I guess that's where now we're in a weird place here. But you see what I'm saying, though? Anyways, I got to get going, you guys. Thank you all very much for your support for the channel. It's possible I might try to come on later. At my son's apartment, apparently, they had a 2-bedroom there, and there's still a mattress in there, I guess. So, I guess there's, maybe we can hang out over there or something like that. I don't really know, but thank you all very much for being here. And I wish I had the outro or anything, but I don't. And thank you very much again. And as I always say, until next time, be safe out there. And thank you guys. Oh, Jesus. God damn. You hear that?